Good morning, everybody, and good morning, Ruth. My name is Beth Shibley, and we're here with another Caregiver Conversation, and I have Ruth Rhodes from Rhodes Law in Brevard County here today for a conversation on, trusts, wills, documents that we all need to worry about. Like I said, good morning, Ruth, and
Good morning.
welcome to Caregiver Conversations.
Thank you. Thank you. I'm happy to be here.
Okay. I'm going to make Ruth host. There you go, Ruth. So Ruth will start by, if you'd like to share your screen and then tell us a little bit about yourself, Ruth.
Well, good morning, everyone. My name is, can you see my screen first?
I can. Absolutely, we can.
Okay. So my name is Ruth Rhodes, and I am a solo practitioner attorney practicing in the area of elder law. I have two locations, one in Melbourne off of Sarno Road and another location in Vieira at One Senior Place. I've been practicing law since 2006, and I've had my own practice since 2010. And one of the wonderful things about having my own practice is I get to do and practice law the way I want to. I get to provide the types of services and quality of service to my clients the way I want to. And I just love that because, we here at Rhodes Law, myself personally, and all of my paralegals, we just love helping people, and it brings a lot of satisfaction to us. And we especially love helping the elderly people and the people who love and care for them. So it's our pleasure. It's not, what they say is when you do what you love, you never work a day in your life. Right. And that's how it is for me personally, and for my staff as well. We love what we do. And just to tell everyone too, is we're very much into education. So we do present seminars regularly, and with Aging Matters, and also at One Senior Place every month on the third Wednesday of each month, we present a seminar as well. So we're going to be doing estate planning today, but in March, we're going to be presenting a little bit more in depth a little later this month on the third Wednesday, a little more in depth on estate planning. So if anyone's curious about really diving in, join us at our seminar, and you can do it in person. Can you believe it? Or you can do it on Zoom. And you can get the information just by going onto my website at www.rhodeslawpa.com. That's RHODESLAWPA.com. Sometimes when I say my name Rhodes, people think I'm saying the flower rose. So that's why I always like to spell it out. But I'm ready to start anytime you are.
Oh, just one quick question. Ruth, are you expecting that your seminars that you're now doing in person will continue to be also online now, even after we're through with this, or are you planning on going back to just live presentations?
Well, we will probably do both, continue with both. We, at the beginning of the pandemic, we invested in some software that helps us do that. And I love it. I think it's great. And one of the things, one of the feedback that I got was people who normally would not be able to come in person because they work, and, they just can't make it to the seminar, and they really enjoyed listening to the online presentation. So we'll probably continue doing that. And one of the positive things that came out of this whole COVID situation, I think, is how everyone is learning and having the capability to be able to do these online. And I know as a practicing attorney who goes to court frequently, I am hoping that the courts keep this online thing too, because I've been able to take care of hearings for clients here at my desk, saving them a ton of money, because now they don't have to pay me to drive to the courthouse, sit in the hallway till God knows how long, and then drive back. Now I can sit here at my desk. I can have the video ready to go, waiting for the judge. And in the meantime, I can be taking care of other things and not charging that one client for a lot of wasted time. So I think it's been very efficient, and I think it has been a wonderful thing for us, so I'm hoping
I think we all got kind of pushed into the deep end of the pool when COVID happened with being in this electronic world. But I think we're all starting to learn how to swim now, and the water's not as cold as we thought it was going to be.
Right.
And I think that it's been a good thing. All in all, it's been one of the few silver linings that we've had about the entire thing. That it has opened up that whole world. And you're right, there are people who are working and there are people who are caregiving.
Yeah.
Where it's a huge burden to have to be able to take, and it's not just the time you spend in your office or in someone's office or coming to Sunflower House for a seminar. It's the driving over, it's the getting somebody to watch them, it's the driving back, it's a half a day.
Yeah, and it's the gas.
And the gas. That's right. That's right.
Yeah, I think this has been a real convenience, and I hope that we keep it. I hope so too. The capability. So I know it's my intention so that when we do our seminars in person, because I think we need to have those options available for in person. And we're doing it safely. One senior place has very strict guidelines on how many people can come in person, and they set up the tables with reservation names so that when you reserve a spot, you have a table, and it's going to be at least 6 feet from the next set of people. So and they're still wearing the masks and practicing social distancing. So if anyone that's nervous, they can feel a little more comfortable being there in person, knowing that precautions are being followed very strictly there.
Yeah, and yes, I've been to one senior place and I agree. I think that they're really doing a really good job of making everybody feel as comfortable as they possibly can in this environment. So they're just, way inside the line of the worries. We're not going to be doing any mosh pits.
Yeah. No mosh pits, not yet. So.
Okay. So estate planning.
Yes. All right. So today we're going to talk about estate planning. And just to begin with, information that's being shared today is for information, educational purposes only, and is not to be relied on to make decisions in your personal affairs, because it's very general information. So it's also, not only should you not make decisions based on information you received today, but it doesn't create an attorney-client relationship. So, but if you need help, I do want you to know that I'm available, and we do offer free consultations. But the information today is just for education purposes. So that's my disclaimer. Every attorney has one. And today we're going to be talking about important legal tips for caregivers, and it's going to be really focusing in on what you should do as a caregiver for yourself, plus discussing different estate planning options.
Okay.
So the easy for me to say, the objectives during this presentation, we're going to be discussing the important legal tips for caregivers, getting your legal checkup, knowing your plan, getting educated, and any estate planning pitfalls to avoid. So first, we're going to discuss getting your legal checkup. First thing you need to do when you are thinking about your own situation is you need to have someone who can help you and guide you, because there's so much misinformation out there on the internet. Of course, Google knows everything, right? But there's a lot of misinformation out there. So it's important to be guided by someone, by an attorney, not just someone, but by an attorney who practices in elder law. I cannot tell you how many times it's insane how many times I will get documents brought in that were prepared by a family law attorney, by a criminal law attorney, by a business law attorney who thinks that just preparing a will is so simple, or preparing a trust is so simple, or a durable power of attorney, how hard could it be? And I see documents prepared by attorneys that don't focus on this area of practice. And some of those documents are just so scary. And the problem with that is, if you have a document that's not going to be valid or legally recognized by maybe the banks or the financial institutions, or the hospital, for goodness sake, you usually don't discover that problem until it's too late to make changes, right? Because who tests their documents? You don't usually test your documents until it's time to get out there and start using them. And you cannot sign legal documents unless you have capacity to sign them, legal capacity to sign them. And most of the time, people aren't using powers of attorney until there's a problem with the loved one. And that's a terrible time to go testing documents. And if you have a bad document that doesn't do what you expect it to do, the results could be much, much more expensive, or not just money terms, but in other terms as well, expensive in time consumption and other types of expenses that could be involved, that could negatively affect you or your loved one.
I'm also thinking about all of the emotional and psychological expense that goes into having to add that burden onto what's already an extraordinarily stressful time, whether you're talking about, a power of attorney when somebody's become incapacitated, or when you have a loved one that's passed away, to have to then all of a sudden have to, in effect, be working without any of these documents because they're not worth, they're not going to be recognized, is,
right.
I don't know that any of us would choose to put our loved ones through that. And that's really what at the end of the day, these things that if you take me, for instance, these things that I'm putting in place aren't necessarily for me, because I'm going to be past the point where it's good. They're going to be for my loved one, my husband, my children. These are for the people that I care about, to make their lives and their world easier when I no longer can do that. So, really, truly, we're doing it for the people we love,
Absolutely. And the audience of this presentation are caregivers. Many of them have probably gone through a lot of stress that could have been avoided had their loved one that they're caring for prepared properly. So let that be a lesson to you that you don't want to leave your family in that situation. And if you're one of the caregivers that are fortunate enough that your loved one actually did do the planning, then let that be a good example to you of what you should also do. Because like you said, when you're in that crisis mode of trying to just care for someone you love, and then on top of that, you have legal issues that you have to deal with, that can just be so overwhelming. And it can be easily avoided. So, like they say, an ounce of prevention is worth a pound of cure. And it's really true. It really is. And one of the other benefits of having an elder law attorney in your corner is we, as elder law attorneys, are well connected generally with types of services and people who serve this community. We know social workers, we know elder care coordinators, we know senior living and nursing home people, and we can help connect you with folks that can make your life easier. So that's another reason that you would want to choose an attorney that practices and focuses their practice in elder law, because we're going to be able to connect you with other people who can help you with other things besides your legal issues. So who needs a legal checkup? Well, a legal checkup is not only for your loved one, but it's also for the caregiver. So remember the cardinal rule, you always put the oxygen on yourself before you do your loved one. So if something were to happen to you as a caregiver, who is going to take care of the one you are caring for? So we want to make sure that the legal needs for everyone is taken care of, not just the loved one that you're caring for, but yourself as well. So we, as elder law attorneys, as estate planning attorneys, we think of, what ifs, and we want to put layers of protection in place. We want your plan A, we want your plan B, and we want maybe even a plan C, so that, these contingencies that could pop up, we can have at least a plan for it, because you can't foresee everything, but we can plan for things. So we want to know your plan. And what does it mean to know your plan? Well, first of all, you have to have a plan, right? A lot of us don't even have one. So it's still March. It's early in the year. These New Year's resolutions, don't sweep them aside. Get yourself organized this year. Get your checkup. Get your estate plan in order. Make an appointment and at least have the discussion. So when you have the discussion, though, you want to have some things in mind. You want to think about decisions that need to be made. Who will I put in charge of myself? Who are going to be the successors? So that's your plan A and your plan B, plan C, of who's going to be helping you. How do I divide up my estate? Just kind of some thinking on how you would divide things up. And I know a lot of us don't have a lot, and you might think, I don't have that much, I don't need to worry about that. But there's more to it than just stuff. All right. What if someone important in my estate plan, so like, for example, you already have an estate plan, but what happens if one of those important people pass away? What happens if one of those important people lose capacity or become disabled themselves? So that's one of the reasons why we want to have these contingency plans, these plan A, B, C, etc., in place ahead of time. But if you already know that these things have occurred, you definitely need to have everything reviewed and maybe tweaked. Also, what if I have a major life event? What if I get married? What if I get divorced? What happens if I adopt a child or a grandchild is blessed on us? Those things could affect the way you might want to set things up. And how do I protect my assets in the case, and myself, my personal body and care in the event I become ill? These are things that we all want to think about. And those are things that I will talk to you about if you were to come to meet with me about estate planning. I would ask you these different questions. And then once you have your plan in place, once you have an idea of what you want to do, then you need to talk to the people who are going to be playing an important role in that plan to make sure they're on board, make sure they're willing to serve. And also then once you get your documents set up, you don't need to share your documents. And I would say most of the time that you should not share your documents right away. But they, at least these important people, need to know where the documents are located in the event there's an emergency. Right. And the reason why I caution about sharing your documents is because sometimes you might change your mind. You might decide, maybe I really don't want that particular person as my number one. Maybe I might want to make them number two, or maybe I don't want them at all serving. So we don't want to have multiple types of documents floating around out there that could be misused, because unfortunately that does happen. So unless there's an immediate need to share documents, I suggest not sharing documents and just letting them know where to locate them. So like in my particular law office, we offer a free service where we will hold your original documents in a safe deposit box, and no one will have access to them unless and until certain criteria is met. For example, if the person you named, it has to be the person you named, not just some random person, says that something has happened to you, maybe there's some emergency with capacity or your health, and we don't just take their word for it. We're going to want them to provide some kind of documentation or evidence to that fact before we release the documents, and that way your documents are secure. Or you can keep them in your own safe deposit box. But the problem with that is the person who you name needs to be able to have quick access.
Yes, they have to be on that. They have to be listed as being able to use that, access that safe deposit box.
Exactly. Yeah, exactly. Because if they're not listed, guess what? Now you have to get a court order to open that box.
Yeah.
Yeah. And in the meantime, if there's an emergency,
right.
I don't need to even go there. Everybody understand that's a time consuming process. Anytime you have to go to court, I hear money, ching, 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 and time. Oh, goodness, time, because the wheels of justice, they roll very slow, So just some things to think about. The next thing we want to do is we want to get educated. We want to know about the things we need to know. So what is estate planning? That's something that we need to know. Regardless of whether or not you have a lot of wealth, you need to have a plan for what will happen to your assets, to your family, and to your own personal care in the event of your incapacity or your death. Estate planning, in a nutshell, is the preparation for the transfer of a person's assets after they've passed away. But estate planning also includes planning for incapacity. And to me, that's one of the most important things, because you need to take care of yourself, right? And if you become incapacitated, I would want you to have the security of knowing that you're going to be okay, because you have legal documents that are putting people in charge that you trust, that you chose, that know you and know what you want, rather than leaving it up to luck as to who's going to be in charge of you. And if you lose capacity and don't have legal documents in place, the next step is guardianship. I don't know if you're aware of that or not, but
yeah, that's a brutal step for families to have to take, to go down that path.
sure.
I'd like to have you, if you wouldn't mind, you talk about being legally incapacitated. You're talking about physically or mentally the inability to care for yourself. If you could give me sort of a back of the envelope definition of what it means to be, legally incapacitated.
Okay, so legally, to be legally incapacitated, that is actually something that's done by a judge. There's a couple of different types of incapacity, in a sense, in that if you have legal documents, your legal documents may give a definition of what incapacity means to you. And generally, in my legal documents, and most generally drafted legal documents that are done by elder law attorneys, the legal definition usually requires 2 physicians, one being board certified in the area that is most closely affecting your incapacity. Both of these physicians signing an affidavit saying that you're no longer capable of making legal decisions for yourself anymore. So that's one type of incapacity that can trigger your loved ones to be able to take over. But again, that's only if you have legal documents. If you don't have legal documents, then the other type of incapacity is the type that is done through the guardianship process, where you are examined by 3 different members of an examining committee, and they each report back to the court on what they believe your capacity to be or incapacity to be. And they make a recommendation to the court on whether or not you should be subject to a limited guardianship or a plenary, which is a full guardianship. And then the court holds a hearing, and you have a trial essentially on whether or not you have capacity. And if the judge finds that you don't, then you are declared incapacitated.
Mhm.
And at that point, the judge would be required to determine whether or not you should have a guardian, or if there is a lesser restrictive alternative available. And
Mhm.
that's an important thing to understand. A lesser restrictive alternative can be a durable power of attorney and a healthcare surrogate designation, and maybe even a trust could all be considered lesser restrictive alternatives. In
Mhm.
other words, these documents can be used to take care of you so that you don't have to become a subject to a guardianship. And the reason why courts are required to look for these lesser restrictive alternatives is because guardianship is very severe. When you
Mhm.
become subject to a guardianship, you become a ward of the state of Florida. That's where I practice.
Mhm.
And now suddenly the court is all in your business. They will be given all of the information about your financial life, all the assets you own. They will know everything about that. They're going to know about your care, where you live, what doctors you see. This is all part of the guardianship process. It's very invasive of your privacy, and not to mention it's very, very expensive, and not only expensive to establish.
Mhm.
$5,000 to $10,000 is not unheard of to establish a guardianship that's not contested. But
Mhm.
not only is it expensive to establish a guardianship, it's also expensive ongoing, because your guardian is required every year to report to the court, and your guardian is required to have an attorney. So it's a bleeding of your finances. So
Mhm.
here again, an ounce of prevention is worth a pound of cure. So compared to the huge expense that guardianship can be, and when I said $5,000 to $10,000, that's for an uncontested
Right.
guardianship. And I cannot tell you how frequently these things become contested. They can be just as ugly as a divorce with custody proceedings. And I'm not exaggerating.
Oh,
Anyone
I
that's had to deal
absolutely.
with it. Yeah. So it's well worth the investment to have a very good estate plan put together for you. Not only for saving money, but also for your privacy. Because
Well, and I also think I also know of folks that getting involved in in guardian, it can tear families apart. It can tear
oh,
siblings apart. It can tear entire generations apart.
it
Um,
sure can. It sure can. And it can be very ugly. And so if you have something in writing where you're saying, this is how I want things to be, that can
mhm,
help your children say, you know what, this is what mom wants. This is what dad wants. This is what grandma wants or grandpa wants.
right.
And then they can maybe feel better knowing this is what you wanted. And
Mhm.
instead of guessing, no, this is what grandma would have wanted, or this, and they fight, like you said. Oh my goodness, I have seen families just ripped apart. And once that happens, it is hard, very hard for them to ever heal and get back to being a real family again. It is, in fact, when it does happen, it's like, wow, that really happened. I mean, that's how rare it happens.
Mhm.
So it's very unfortunate. So again, the expense of preparing is much less than having to go through the guardianship proceeding, because the emotional toll, not to
Right.
mention the other issues that we discussed.
Right. Absolutely.
Yeah. So with the estate planning, who needs estate planning? So nobody can predict the future, right? We don't have a crystal ball. We don't know what's going to happen.
Yeah, I've checked the bottom of my feet and I don't have any expiration dates. I don't have any use by date.
Right. And thank
Okay,
God
every
for
time I
that.
put my class, yes, I know.
Yeah, thank God for that, because I mean, I don't want to know.
Yeah, that's right.
But who needs estate planning? In short, just about everyone should have some form of estate planning done, even someone as young as 18. Under the age of 18, your parents are your natural guardian. They can make decisions about everything for you. But the day you turn 18, your parents no longer have the ability to make legal decisions for you. So even someone as young as 18, I think they don't need a full-blown estate plan. I think just a durable power of attorney and a healthcare surrogate designation would be sufficient, especially for someone who's going to be going off to college. Those two documents can save a lot and help the parents a lot too, because oftentimes as parents, we're helping our young adults take care of things. And this would be a legal way of being able to do it for a very little cost. So as young as 18, you should think about at least a durable power of attorney and healthcare surrogate.
Mm-hmm.
And it doesn't matter how much money you have, and it doesn't matter your marital status. Some people think, well, my husband or my wife, they can take care of things for me, right? But the answer to that is maybe not. So it really depends. And I can't tell you how many times I've had to file guardianship for a husband to take guardianship over his wife, or for a wife to take guardianship over her husband, because just because you're married does not give you the ability to make legal decisions for your spouse. I know that might be shocking, but it's true. And it doesn't matter if you don't have children either. I mean, if you have children, your children don't have an automatic right to make decisions for you. So again, who needs estate planning? Well, just about anyone over 18 needs at least something done. And at a minimum, I would say at a minimum, durable power of attorney, healthcare surrogate, at a minimum.
I have to say the flip holds true too, Ruth. I can remember years ago when my husband and I were first setting up our wills, we didn't even think about doing any kind of estate planning until we had kids and we bought a house. And we were in our 30s by the time. And we had, and that was much later than we should have done it, but I think there are trigger events that I think make us start to think along those terms. But now looking back on it now, we should have done it earlier than we did it.
Yeah. And if you do have minor children, it's especially important. It really is, because if something happens to you as parents, who's going to be in charge of your minor children? And that could be a contentious, litigious situation where family members are fighting over who gets to raise the kids. And I think as parents, you should be able to choose who you would want raising your children. You know these people in your family best, and you know who would be a good surrogate parent to your child and who would be not so good.
Here's a small little quick horror story that I have from decades ago that I had heard, that there was a situation where a couple was in a horrible accident, and they both passed away, and they had minor children that had survived. They weren't in the car, but the husband had been driving drunk, and so he caused the accident, and he and his wife died because of that. And the mother of the mother's parents, the wife's parents, were so brutally devastated by this that they cut the family members of the father off from seeing the grandchildren. And
That's
so,
terrible.
but those are the kinds of things that can happen if you don't have those things in place. So it makes sense to think through, that sort of thing. So, we never, I mean, the situation would frankly not have occurred with my husband and I, just because he didn't drive drunk and I don't. But we certainly made it clear in our will that the grandparents and the extended family on either side would continue to. That was our wish, that they would have the right to have access to their grandchildren.
Absolutely, because when you do things like that, you're only counting the children.
Right.
As long as the extended family are good people and they love the grandchildren, it does nothing but benefit the grandchildren to have relationships with them.
Right. So, so those are the kinds of things that had I not heard that horror story, I don't know that I would have thought about that, but it certainly entered into our thinking when we decided to, we're going to get a will started and we're going to make sure some of these things are in the will. So that we have these things in place.
That's great. That's great. And you get to take control too.
Absolutely.
So, you get to choose who, for the most part, get to have a good choice on who you would want raising your children. And that's
And who has the capacity to do it, and who you think will there's, it's having children is a wonderful thing, but it does not come without burden.
And the temperament, you want to make sure, the temperament too. That's a very emotional subject. So you got to put a lot of thought into it. So like we said earlier, there's no prediction. We can't predict the future, but we can plan for possibilities. And that's where we have our contingency. We will have our plan A and our plan B. And there are dozens of reasons why estate planning is important. Here's just a few of them. You want to protect your children's inheritance. So that is a good example of that is you're married, you have children with your first spouse, your spouse passes away or you divorce, and then you remarry. And you want to protect those children from the first marriage. You want to protect their inheritance. Because without proper planning, whatever you have may end up going to either your current spouse, the new spouse, or to even their side of the family. And you could, if you're not planning properly, you could end up disinheriting your own children. So we want to make sure we're protecting your children, also your grandchildren, if that's something important to you.
Right.
Protecting your disabled loved ones. Reason why that's important is because oftentimes disabled folks are receiving benefits, and these benefits sometimes are considered need-based. And if they are need-based, it means that they usually have to meet some type of income or asset limits. And if you were to leave them a large or even not so large inheritance, you could disqualify them from a very important program that they need. For example, Medicaid. That one always pops in my head because Medicaid is gold. It's worth its weight in gold. I mean, if you have a Medicaid card in Florida, it's called a gold card. It's called a gold card for a reason. It's valuable. And with Medicaid, you're often limited to less than $2,000 of assets. So it doesn't take much to disqualify someone from Medicaid. So there's tools that are available that would allow us to leave gifts to your disabled loved one without disqualifying them from the very important benefits that they are receiving. Also protecting minor children. Minor children are not allowed legally to own things. So if you are going to be leaving gifts to minor children, you want to make sure that you have the proper vehicles in place so that whatever you do leave to your minor children in your life, whether that be your own or grandchildren, that those benefits, those gifts are protected for them. So we want to make sure that we have the proper vehicle in place for that. Also, it's drilled into our head, avoid probate, avoid probate, avoid probate. So most of the time, I mean, there are ways of avoiding probate outside of estate planning, but they're very limited. So there are vehicles available within the estate planning process to avoid that probate, whether that be through using a trust or ladybird deeds, or making sure designations of beneficiaries are set up properly. And that's all things that I would discuss with you.
Mhm.
I would go over your assets one at a time and scrutinize, is this asset set up to avoid probate? And if not, what do we got to do? And I'll give you the information on different options, and then, you know, the education on it. And then you tell me what you want. So we would do that. Also, avoiding guardianship, like we were just talking about, that's part of the estate planning process. We want to avoid guardianship. I think that is just a number one priority, is in my book. Also, you will have the ability to appoint trusted folks that you want, your choice of who's going to be helping you with your personal affairs. Who's going to go get me ice cream, right? I always think about that. Who's getting me ice cream? Dang it. And that's important. I want to know who's getting me my ice cream.
Well, yeah, absolutely. You don't think, yeah, you got to keep important things first things first. You know, I would say that, you know, the people that you want, not necessarily the same person in charge of both of those things. The person you want to help you make your medical decisions, you know, healthcare surrogates, might not be the same person you would want as the executor of your will.
Right, exactly. Or the durable power of attorney, the agent.
Power of attorney, right.
You know, and so that's something that we would discuss. We would not just name your children in age order, because that one's the oldest, and so that one should be in charge. We would actually talk about it and say, well, is that one have a good head on their shoulders for handling money, for handling finances? How do they treat their own finances? Are they responsible? So we'd want to talk about that. And when it comes to healthcare decisions, we don't want that child that's highly emotionally charged making healthcare decisions for you. We want the level-headed one that is going to follow your wishes and not be ruled by their emotions so much, because that's a tough situation to be in, to be the one that makes that healthcare decision for someone. And you want to make sure it's going to be someone that is not only going to honor your wishes, but they themselves can emotionally handle it. So we'll talk about that. Don't just name your children because of age order. I've seen that done so many times, and it's not always
gender, or their gender, or their gender,
or gender, you know. Or gender. Exactly. You want to name the right person, and we would discuss, should it be one person and then a successor, or do you want to do joint decision makers, and the pros and cons of that, because there definitely are pros and cons. When you have joint decision makers, as long as they get along like peas and carrots, that will be okay. But the minute there's a problem, you're talking hiring attorneys and bringing it to the courthouse. So we have to discuss that. Do you really want to have to make children work together? Because you never know what's going to happen. You know, not everyone agrees on everything. So that's part of the process too, is to talk about, you know, the pros and cons of each decision you're making. Also, estate planning documents can be used for directing your family and your physicians on how to make healthcare decisions for you through a couple of different documents, the advanced directives, in other words. That would be your designation of healthcare surrogate and your living will. Those two documents work together essentially to make decisions on how your care is to proceed all the way through your passing.
Right.
And have an estate plan is very important too, for avoiding the bitter family fights that we were talking about. And those fights can make already difficult, stressful times even more troublesome. And like you said, tear up families. So it's worth it to avoid that. just by having a simple plan in place, you could avoid that.
Well, I mean, families can get torn up, even if they didn't have these problems, so why add this on top of what is already going to be, you're right, a very stressful situation.
Exactly. And even if you do have an estate plan, it's not foolproof that you're not going to have it. Like you said, families have dynamics. Always. And having a good estate plan isn't going to cure dynamics, but it could help. And at the very least, if it becomes a full-blown litigated situation because you have bad family dynamics, at least there's a guide for the judge and in the case that ends up being in front of him or her of what your wishes would have been. And the judges do try to follow your wishes. And the law says that the judge should follow your wishes. So at the very minimum, you'll have your wishes in writing. Hopefully it doesn't get to that, but it sometimes it does, unfortunately. But at least it's in writing, and we know what your wishes are when you had capacity to make those types of decisions. So the different types of estate planning documents, there's a lot of different ones, but I just wanted to present the more common ones that we use regularly. So trusts, and we'll go over trusts and what they are in the next PowerPoint slide. Last will and testament, durable power of attorney, designation of healthcare surrogate, living will, declaration of pre-need guardian. These are the more common that you're going to see in most estate plans that are prepared by elder law attorneys. So trusts are legal instruments, okay? And they are created to hold, protect, and manage assets for the benefit of a person or persons. It's kind of like a corporation. A corporation owns nothing until you put it into the corporation. And that's how a trust is. A trust really is a piece of paper until you put something into the name of the trust. So there's a lot of different types of trusts, but we're only going to talk about the top 4 most popular ones that we use as elder law attorneys. Those are the revocable trust, the irrevocable trust, the special needs trust, and the qualified income trust. Now, a revocable trust, that's your most common type of trust. It's the type that can be amended or changed. It's not etched in stone. If you need to make changes, you can. And that's your most common type of trust that most people, when they prepare trusts, that's what they usually will have. And these trusts are drafted to not only take care of you first, you're the first beneficiary generally, and it's designed to take care of you through incapacity. And then it's ultimately used to pass on your estate the way you wish it to be done. And it can be used to avoid probate. So trust can be used to not only avoid probate, but because it's got incapacity planning in it, it can also be used as a tool to avoid guardianship. So it's a wonderful vehicle that we use for those two things. An irrevocable trust, not so common. It's usually used to protect assets, asset protection, and sometimes used in Medicaid planning. But when it comes to Medicaid planning, it's important to realize you have to be really careful. Don't go it alone, because if you don't do it correctly, you could end up disqualifying yourself from Medicaid. And that can be a subject for another day. Special needs trust, that is that vehicle I was talking about, kind of alluded to when I was saying, how do we take care of our disabled loved ones? How do we leave them gifts without disqualifying them from important government benefits? Well, a lot of times we're going to use that special needs trust as a vehicle of doing that. And so that is really important thing to know. And then the qualified income trust, that goes along with the Medicaid planning process. So as you know, Medicaid is it's a needs-based program, so you have to meet income and asset criteria. But what happens if you're over income? We can still qualify you by using a qualified income trust. So that, and I think we should have a discussion on Medicaid planning. I think it would be.
Oh, yeah, I think it'll be a great one.
A great one to go over for sure. Then last will and testament, everybody knows what a last will and testament is basically, but it's a legal document in which an individual records their wishes on how they wish their possessions and affairs to be handled after they die. A will is not an active document until after the person passes away. There's two types of wills that I generally will use. It's going to be a standalone will that doesn't need anything else to work with it. And then a pour over will, that's another type. And that is a will that works with a trust. So even if you decide, you know what, I want to have a trust because I want to avoid probate, you're still going to get a will. You're going to get a pour over will. And what it basically does is it says whatever's in my estate, which is not inside the trust already, I want that to pour over into the trust and let the trust handle it. And the reason why it's important to still have a will, even if you have a trust, is because not everything in your life can be held in trust. So for example, if you were to pass away as a result of medical malpractice, your estate handles that, not your trust. So your person that you put in charge of your estate and your will, the personal representative, that would be the only person that would have the legal authority to sue on your behalf. And then if they do sue on your behalf and they get an award, because it's a pour over will, whatever money comes into the estate, it pours over into the trust, and then the trust does the distribution. Also in wills, you can tell and give directions on how you wish to be either buried or cremated, and you can be as explicit and detailed as you want. You can say, I want to be cremated, brought out onto a boat over a certain point in the ocean. While my ashes get dumped in the ocean, I want this particular song being played. I mean, you could do as much as you want, or as simple as you want, like just bury me and or burn me and toss me out. I don't care. You know, as simple as or detailed as you wish. It's up to each individual what their desires are. There's also a document that you can attach to a will, so you can do changes with personal property without having to do your whole will over. So you can have this little writing added on where you can actually handwrite it in, date it, and sign it, where you can say, as to personal property, tangible personal property, that you wish for my gold ring with the 3 rubies to go to my niece, Caroline. You know, as long as you properly describe it, you date it, you sign it, and you keep it with the will, it's a legal instrument. And you don't have to update your whole will to do that, which is great. You can also in your will, like you mentioned, you can name your guardians of your minor children in your will. You can name who's going to be in charge, and in Florida, that person is called personal representative. I know some states call that person an executor or executrix, but in Florida and in many states, it's the personal representative. And some people ask, why do I need a will if I have designated beneficiaries on all of my financial accounts? So some people will say, I don't need it because I only have a bank account and I've already named my daughter or my son, or however you have your designation set up, as my beneficiary. So I really don't need a will. That's kind of like the same scenario when I talked about why you still need a will, even though you have a trust, because you don't know what you don't know is going to happen. So we want to make sure we are planning appropriately for contingencies. So even if you think, you know, I'm going to avoid probate because I have these designated beneficiaries on my accounts, you may still want to have a will because you don't know, and you won't be here to help fix the problem, right? So plan ahead. That's all it's about, planning. Durable power of attorney is a very powerful document. Sometimes it's referred to as a POA or a DPOA, and it's a document that allows you to appoint a person or an organization to manage your personal and financial affairs if the need comes up, or if you become incapacitated. So in Florida, it used to be that you could sign a POA and it would be an inactive document until you are declared incapacitated by two physicians. It used to be that you could write a power of attorney like that. That was called a springing power of attorney. In other words, it's inactive until something springs it into action. In 2011, the law changed. No longer are we allowed to write those types of powers of attorney. Now, when you sign a power of attorney, it becomes an active document the moment you sign it. That's one of the reasons why I say don't share your documents.
Mhm.
Yeah. But so if you have an old power of attorney, you might want to consider getting it updated.
Mhm.
It empowers your agent to be able to act on your behalf as to your assets and liability. Now, the person that you name in charge in your durable power of attorney, they'll either be referred to as your agent or your attorney in fact. But that's the person that you're naming to make decisions for you. And again, you can do layers. You can name your daughter, your son first, and then the next child, or if you don't have children, a trusted friend or relative, or if you're not fortunate enough to have family available to serve in those roles and you don't have friends, which sometimes happens, especially as we age and we outlive everybody around us. It's a wonderful thing to be able to live that long, but at the same time, it can be very lonely. So sometimes we have to choose trusted professionals to serve in those roles. And as an elder law attorney, that's what's important here too, is I have connections of people who are trusted in the community to act in those roles. And like I said, once you sign that power of attorney, it's immediately effective. So we want to choose wisely and don't share documents until it's absolute time. Okay. Designation of healthcare surrogate is a document that allows you to name another person as your representative or as your surrogate to make medical decisions for you in the event that you become unable to make them for yourself. So even though you sign, this is a little different than a power of attorney.
Right.
Power of attorneys become effective immediately, and it deals with finances and your property rights and things like that. Designation of healthcare surrogate does not become an effective immediately, not necessarily. It can, but it not necessarily. And the person that you name as your surrogate to make medical decisions for you, they can't override you. So as long as you're able to make informed medical decisions, and that is something between you and your doctor, as long as you're able to make informed medical decisions, you get to make them for yourself, and your surrogate that you named in your document cannot override you. You can include instructions. You can be as detailed as you want in this. You can give specific instructions. I've had clients that have had specific religious beliefs and don't want blood transfusions or don't want certain procedures done on them because of religious beliefs. You can include that in the document. And it's good to have inside the document HIPAA authorization to allow the surrogate that you name to be able to speak to your doctors, to be able to have access to your medical records.
That's really important, Ruth. And I think that unless you're necessarily talking to an expert such as yourself, you might not think of that. You might know, I need to do this living will thing, but they might not think about the fact that your doctor can't talk to you unless you have a HIPAA authorization.
Absolutely. So, and not just not talk to you, they may bend the rules a little bit and talk to you.
Absolutely.
But they probably are not going to release records. You're not going to be able to call the hospital and say, hey, I need to pick up the medical records for my mother or my father. You're not going to be able to do that without that HIPAA release. So it's important that that's in your documents. And I've seen a lot of healthcare surrogate documents that don't have that HIPAA release.
And if you're talking about making healthcare decisions, that's different than the doctor being able to just talk to you about what happened. You're absolutely right. So when I mean talk to you, I mean, to be able to get involved in the healthcare decisions that they would normally be having, the doctor would normally be having with me. Well, all of a sudden now, my husband better have the HIPAA release, and my son better have that HIPAA release, because if they don't, my doctor isn't going to be able to necessarily do that same sort of sharing.
Yeah, there may be some hesitation in the sharing of the information. And how important is it that the person is making decisions for you for your healthcare, but doesn't have access to all the information needed? I think that's a recipe for disaster. So it's really important to make sure there's a HIPAA release language. That way there is no question as to whether or not that person has authority to have access to that sensitive information.
Well, and if you're thinking about somebody wanting or needing a second opinion and being able to take those records and move them to a different doctor or it just goes on and on.
Oh, yeah, absolutely. That's a good point. Very good point. Designation of healthcare surrogate is one of the recognized advanced directives in Florida. Another one is the living will. And some people get a little confused on what a living will is, but it's a document that allows you to direct your healthcare providers on your healthcare wishes if you become incapacitated and are unable to communicate and you're at the end of life. So basically a living will, typically the language is going to be along the lines of, if I am in the dying process and two doctors have affirmed that I'm in the dying process and that there is no reasonable medical probability of my recovery. Now, this is not if you get into an accident and bump your head. That's not the same thing. Right. This is when you're in a terminal condition, an end stage condition, or you're in a persistent vegetative state. That's what triggers it. And two doctors saying that you're in the dying process and there's no reasonable medical probability of your recovery. Then this document speaks for you because you're no longer able to speak for yourself either. You're incapacitated. This document generally is going to, typically, I should say, I don't want to be kept alive artificially. I don't want to be kept alive on machinery. I don't want to be force fed. I don't want feeding tubes in me. I don't want breathing tubes stuffed in my throat. That I want to be comfortable. I want my pain medications to keep me comfortable. I want any procedures needed to keep me as comfortable as possible, but I want to be allowed to pass away naturally without being kept alive artificially. That's what a typical living will say. And I'm going to tell you, out of all the years that I've been practicing in estate planning and elder law, any medical providers that I've had as clients, I have yet to have a medical provider say to me, no, I don't want a living will. Yeah. And I think it's because if you've ever had to witness someone on that type of machinery, it's horrific. And the quality of life is not there. And it's oftentimes the loved one is keeping them alive. The caregiver or the decision maker is keeping their loved one alive because emotional issues, of saying goodbye and letting someone go. But I know I personally wouldn't want to be kept alive like that. And I know where I'm going when I pass away. So let me go. But I think a living will is an important thing to consider. Not everyone wants one. And sometimes I do have clients who say, you know what, I don't really want a living will because I have a healthcare surrogate. And the healthcare surrogate document does provide for all this decision making. So you can have your loved one in your healthcare surrogate document make those decisions for you. But having been a child that's had to make decisions like that for my own parents and for a brother of mine, it's a difficult decision to make. And had I had the benefit of a living will to help me with that process, it wouldn't have been so excruciating. It really is an excruciating decision to make, to let a loved one go. And if they have a living will, at least I could have relied on that and said, hey, this is what my mom wanted. This is what
Right.
my dad wanted, or this is what my brother would have wanted. But unfortunately, I didn't have that benefit, and I would prefer to have had it. It would have been a lot easier for me emotionally. So that's something to consider as a parent is if you're leaving a child in charge, think about that decision and help your child be able to make that decision without the guilt and everything that goes along with it. So I think a living will is an important document to have. And then declaration of pre-need guardian. So all these documents that we talked about are all about just avoiding guardianship and trying to, do our best to do that and thinking about the different contingencies. But sometimes guardianship is inevitable. And typically when you have an estate plan ready and in place and you still become subject to a guardianship, it's usually because your family dynamics is out of control. And the court has to step in order for you to get the care that you need or the oversight that's needed. And what this document does is it allows you to appoint and name who you would want appointed as your guardian. And it's directions to your judge in the future that if I have to have a guardian, these are the folks I would want. And one step further, you can actually use this document to disqualify the crazy people in the family from being able to serve. You know what I'm saying? So, and it's a private document. So when you sign one of these in my office, I'm going to file it with the court immediately so that it's there and it's confidential. Not just anybody can open up that document and see what it says, but it's there so that in the event a guardianship is filed, it alerts the court of what your wishes would have been and what your wishes were when you had the capacity to make those decisions. So this is kind of like a little bit of an insurance for my clients that they get the guardian they would have chosen or, for themselves instead of the luck of the draw and what the court wants you to have.
Well, and every family's different. So, I mean, I would imagine it's among one of the most individualistic documents that you've got that you're talking about. Not every family needs that, but the ones who do probably really do.
Oh yeah. So I want to quickly just kind of go over the estate planning pitfalls to avoid. So the only thing constant in life is that there's nothing ever constant in life, right? Everything's always changing. There's always things going on. So when you do, even if you do have an estate plan set up, it's important that you have it reviewed periodically, and it's suggested every 3 to 5 years. And I know there's a lot of people who don't do that. It's not a one and done type of thing. It is important to keep on top of it, make sure it stays current. But there are some triggering events that it should trigger you to get your documents reviewed. So if you get married or divorced, if you adopt a child or a child is born into the family, if you move to a different state, if someone important in your planning dies or becomes incapacitated, if there's major changes in your assets, or if there's changes in the law, these are all things that would trigger you to have your documents reviewed. But even if you don't know that any of these things have occurred, it's recommended every 3 to 5 years, because who's keeping, when they have a change in the law, it's not exactly headline news. Okay. So it's important to do that. And estate planning attorneys are supposed to stay on top of these things. Also, do-it-yourself documents are, it can be scary. It's like false security. You think you're covered because, hey, I got this durable power of attorney that I downloaded off the internet, or I got from a paralegal service, and look how much money I saved because estate planning attorneys are much more expensive. But those documents may be false security. They may not be up to date with the law. They may not be covering all the things that you need and all the contingencies that we spoke about. And they may be cheap on the front end, but they may end up being very expensive on the back end if they don't do what they're supposed to do for you. So if it's not going to avoid guardianship because it wasn't drafted correctly, or it doesn't have the language needed, then now, instead of spending a nominal amount of money with an estate planning attorney to get your affairs in order, now you're looking at $5,000-$10,000 at a minimum for guardianship that could have been avoided. And not to mention the privacy and all that we went into. So do-it-yourself documents downloaded from the internet, documents done by non-lawyer services or paralegal services. They can be very dangerous. And I would suggest that if you have documents that were downloaded or purchased from a non-lawyer service, or that you drafted yourself, then I think that you definitely need to have them looked at to make sure they're doing what you expect them to do. Elder law attorneys can help make sure that your documents are drafted properly, that they're valid, and that they are going to follow the plan that you want. And that's it for me. And I'm ready to take any questions you have.
Well, I do think, frankly, I know that my husband and I, we recently purchased a home. We moved to Florida. We are woefully behind on that. So I think I probably am going to be giving you a call, Ruth, to have you take a look at what Mike and I are, have got in our pile. I was saying to my husband, in fact, just this morning, we've been, brutally negligent when it comes to that. My children are now in their 30s and have children of their own. And my mother mentioned to me the other day that she really doesn't want to have guardianship of my children anymore, that their wives would most likely object.
Oh, yeah. Yeah.
The children, and you probably could name one of them. So, so I don't know that, even Mike and I need to, physician heal thyself. I think we do need to get on that. So,
yeah.
So, I really appreciate your bringing this up and just sort of doing a baseline education so that we can kind of understand the differences. Just to be able to noodle it around in your head, it isn't something that necessarily you just wake up one morning and say, oh gosh, I'm going to do this, and I know all of those things. It does take some planning, I think. And one of the things that I think it's also important to make sure is that you do have, maybe not necessarily share the documents, but I'm hoping you'll agree with me. It's important to make sure that your family members, especially those that are listed in your important legal documents, know that and understand that and agree to that and have an understanding that, hey, listen, this is in place. So that you don't get too far down the pipe without anybody realizing, oh, by the way, oh, gee, I didn't know mom had a,
Right, right. I agree 100%. You have to have that conversation with,
right.
I think it doesn't have to be all of your loved ones, because maybe there's some that you don't, but I think for sure with the ones that are going to be the decision makers, you at least need to let them know, hey, look, I've drafted documents and they're with my attorney or wherever, if you have it in your own safe deposit box, and this, so that they know where to locate them in the event of an emergency. Now, if you decide to put them in your own safe deposit box, then the decision maker needs to be have access, and so you'll need to bring them to the bank.
Mm-hmm. One of the things that my mom has me listed as her person for a lot of these things, and I know that I've got the name and the address and the telephone number of the attorney that drafted all of these. I've got all of these. I know where her stuff is, and she will frequently review it with me. I know what drawer she keeps these things in. I know where she has this stuff. Now, those are the kinds of things that I think that it shouldn't just be a one and done. I think you need to, on a regular basis, kind of say, okay, we moved, or I got rid of that desk, so we didn't, or I got rid of that safe deposit box, so I put it here, or it's with this person.
Right.
So,
Definitely. Those are things that could trigger a review. And even if you don't realize something has occurred that should trigger a review, then periodically 3 to 5 years is what's suggested. Bring them in, have someone look at them, make sure they're still going to do the work you need them to do.
Well, because not always not is it maybe necessarily about the fact that something's changed in my life, but the laws might have changed.
Absolutely.
The courts might have changed the way things work, so, and every 3 to 5 years, it doesn't hurt to look at it again.
Yeah. And, lawyers can't leave things well enough alone. The legislatures can't leave things well enough alone. Things are always changing. And I know 2019, 2020, lots of changes in the law, little things, especially in the guardianship arena, especially. Yes. So it just doesn't hurt to have someone at least look at it, make sure that your documents are protecting you. I mean, what's more important in your life than your own life and your own care and your own, who's taking care of you?
And who wants to be able to may have somebody else have to make all of those decisions without you having any input into that.
Yeah, and that happens in guardianship.
Absolutely.
If you don't plan properly and you end up having to go through that, a judge will make the decisions.
Right.
And because of the rules of evidence, your children or whoever is involved may not be able to bring forth to the judge everything that's important that the judge should hear. So just having those documents in place may help avoid that situation. And then if you can't avoid it, it at least is a guiding principle for the judge in the case to know what your desires were. And they're required. There's a presumption in the law that the person that you asked to be in charge of you as your guardian should be appointed. So there's a presumption that would have to be overcome to not get what you wanted, So.
Well, I thank you very much, Ruth, for spending the morning with me and giving me some stuff to think about. And I think I'm going to go grab a cup of coffee and have a serious conversation with my husband.
And I'm here to help if you need any help, no problem. And any of your listeners, if they want to reach out to me, I'm available. We do free consultations at my office, and our telephone number, if it's okay, I'd like to give it out.
Yes,
okay.
Absolutely.
Great. It's 321-610-4542. That's 321-610-4542. Or you can reach out to us online because, some people, they don't want to talk anymore. They want to do everything electronically, and that's fine too. You can contact us through our website, and that's www.rhodeslawpa.com. That's RHOD as in David, ES as in Sam, LAWP as in Paul, A.com. And if you go to the contact page, you can send us a note, and then we'll get back to you and get you scheduled. And, we're here to help.
Yeah, absolutely. I thank you so much, Ruth, and you have a wonderful rest of your day.
Thank you. Take care, Beth.
Bye-bye.
Bye.